Week 6 of The Curmudgeon's Guide to Practicing Law by Mark Herrmann. Here we get into taking depositions. Before we get into how to take depositions, it's important to know why people take depositions. It's to learn facts, establish grounds for dispositive motions, and develop material to impeach witnesses at trial. The instructions, therefore, that lawyers give witnesses at the beginning of a deposition are intended to explain the nature of the deposition. Some people phrase this as a giant block of words. This is bad because it's hopelessly compound and therefore useless at trial. Instead, you should phrase your instructions in the form of several questions. Do you understand you're under oath today? Do you understand your oath is just as binding as it would be if you were sitting in front of a jury? Do you understand you must answer all the questions audibly so the court reporter can make an accurate transcript of what you say? In taking depositions, frame questions that elicit answers that will be useful at trial. It's better to say, "Did you breach the contract?" and get a yes, than to ask, "Tell me about your performance under the contract," and get a long, rambling answer. Working with exhibits in depositions is simple. Get the exhibit marked. Ask the court reporter, "Please mark this as Defendant's Exhibit 1. Ask the witness to identify the document. For slower witnesses, state what the document is and ask for confirmation of that. And then authenticate the document. Is that your signature? Or, did you get this in the mail? Don't bother asking what the document says. Ask what someone intended to convey or what they understood the words to mean. Documents are always subjective. A great question is, who said what to whom when? It can't be objectionable because all it does is elicit facts. Speak like an ordinary person in asking questions, so that when the transcripts are read at trial, you sound normal. Don't ask confusing questions or double negatives. Make sure your questions are answered. Sometimes people don't answer directly, and you have to bring them back to the relevant question. You may have noticed this in the presidential debates. When asking questions, be curious. Get answers about who, what, when, where, why, how. Pretend you're a reporter. Make sure you've done your research before the deposition. If there's a particular piece of evidence that would win you the case, it's good to know that, and therefore be able to ask about it. Sometimes you can use documents to get people to tell the truth. Just having them there might help, if they're afraid that that document you have might contradict their answer. Also, you can get documents admitted into evidence if you can get witnesses to say that they were shown those documents and they jogged the witness's memory. That's sort of the corollary to a tip from How to Defend Depositions, according to the Curmudgeon's Guide, which said that you have to be careful and watch out for the other attorney asking that kind of question. I hope you found this helpful, and therefore will tune in to the next installment of my analysis of The Curmudgeon's Guide to Practicing Law. I think it's a really useful book. Until next time, have a good one.